I'm attorney Martin Nicholson with Law Office of Martin Nicholson, also known as a battery man for my focus on criminal battery cases. Now I'm going to talk about what happens at an arraignment hearing. In Indiana, the arraignment hearing is basically called initial hearing. That's essentially what they end up calling it in Indiana, is an initial hearing. So that's kind of what you're looking at in Indiana, an initial hearing. And what happens at an initial hearing? This is the quick guide. Think of this initial hearing as a formal kickoff of a criminal case. It's your first official appearance before a judge after being arrested and charged, and it sets the stage for everything that follows. The main event isn't about deciding guilt or innocence. That comes much later. Instead, this hearing is all about making sure the process starts fairly and transparently. Your first court date, which should be your initial hearing, your arraignment. And what is it? So, stepping into a courtroom for the very first time can feel like entering a foreign country where you don't speak the language. And this is involving a criminal case. This initial hearing is the very beginning of this journey. It's brief, but fundamentally important procedural checkpoint. The purpose here is administrative, essentially, not really evidentiary. You won't see witnesses testifying or evidence being presented in most cases. The state's not going to try to prove their case. The court is focused on essentially three core objectives that get the case officially underway. The key goals of the initial hearing. Now, the initial hearing isn't just a formality. It serves a critical function that protects your rights and sets the timeline for the rest of your case. The initial hearing represents your first formal appearance in court, where you're officially informed of the charges against you and given the opportunity to enter a plea, not guilty. During this process, a judge or prosecutor sometimes will read the criminal charges aloud, ensuring you understand exactly what crimes the state is accusing you of. The whole process is built around ensuring clarity and due process from the very start. Formal notice of your charges. The court officially tells you the specific criminal charges the prosecution has filed. This isn't a vague summary. It's the formal accusation you'll be facing. Advisement of rights. The judge will explain your fundamental constitutional rights, including the right to an attorney, the right to a speedy trial if you're in custody, the right to remain silent. Also, they'll be asking about entering a plea. You'll be asked to enter an initial plea to the charges. The standard and almost always most strategic plea is not guilty. And oftentimes the court will just enter a not guilty on your behalf. Think of this initial hearing as the legal system's way of saying, here's what the state is accusing you of, and here are your rights, and here is your first chance to respond to those accusations by pleading not guilty. Doesn't mean you're denying everything. It's basically a procedural move that preserves all your legal options while your attorney investigates the case, which is another point. They're going to ask you, do you want an attorney, or do you need to be appointed an attorney, or can you hire private counsel? So that's another thing that usually happens at the initial hearing. Like I said, finally, another crucial issue often addressed during the hearing is your pretrial release. The judge will review or set your bail conditions, determining whether you will be released from custody while the case proceeds and under what specific terms you'll be released. The decision is based on factors like the severity of the charge, your criminal history, if you have any, your ties to the community, if you have jobs, things like that. Now, another question that people ask is what to wear and how to act. So first impressions do matter, especially in a courtroom. While you don't necessarily need a full suit and tie, your attire does send a message. The best approach is business casual. Think of it like a job interview. You want to look clean, professional, and respectful. Steer clear of shorts, t-shirts, especially graphic t-shirts like the kind I wear, sandals, hats. Your behavior in the courtroom is just as crucial. It all boils down to respect for the judge and the process, even if you're upset that you are charged. Arrive early. Things always seem to take longer than you expect. Plan to be there at least 15 to 30 minutes before your hearing is actually scheduled. This gives you time to get through like security, find the right courtroom, traffic, and talk to your attorneys without feeling rushed. Address the judge properly. When speaking to the judge, always use the title like Your Honor, yes sir, no sir. It's simple, non-negotiable rule of courtroom etiquette. Speak clearly and respectfully. If you're asked a question, you may be told to stand up, but maybe not. Just make sure that you are clear and direct in your answers, and most importantly, never interrupt, especially the judge. The main job at the initial hearing is to listen carefully and let your attorney, if you have one, take the lead. If you don't, sit there and listen, ask questions if you have them, and understand that your next step is to get a legal professional. And the court can appoint you one or you can hire one. Now, another issue that comes up is that initial hearing. Sometimes they will have you sign protective orders, or no contact orders, meaning you can't contact people, especially if it's someone that you are accused of harming, battering, stealing, something like that. So you have to sign this, and basically it means, hey, you cannot have any contact with this person, because if you do, then that's going to be a violation of the no contact order, and it can end up interfering with your pre-release and get you locked up or even get you a new case. In Indiana, the clock essentially starts the moment you're in custody. An arraignment, the initial hearing, generally happens within 48 hours, not counting weekends and holidays. That is exactly why you need to make sure you have someone on the outside know that you're in custody and can contact the jail, the court, or an attorney to make sure that you get before a judge and you just don't slip through the cracks, because it can happen. Doesn't happen very often, but it does happen. Now I want to answer some common questions about initial hearings. When you're walking in that courtroom, it's natural to sit there and have a million questions running through your mind. So let's go ahead and tackle some of the most common questions heard from our clients. With some straightforward answers, can my case be dismissed at the arraignment, at the initial hearing? It's the question everyone wants to ask. Can this all just be over right now? While it's technically possible for a prosecutor to drop the charges at this early stage, at the initial hearing, you understand this is extremely rare. The whole point of the arraignment, of the initial hearing, is to get the legal process started, not to end it. A dismissal at an arraignment hearing, initial hearing, would only happen if the prosecutor suddenly discovers a massive, fatal flaw in their case, like realizing they have zero actual evidence. Don't count on it. Pleading not guilty is a strategic move that gives your attorney the time and legal standing to formally challenge the prosecutor's evidence and start fighting for the dismissal down the road. And also it gives the prosecutor time to look at some of that evidence as well. What happens if I miss my initial hearing? Missing your initial hearing is one of the biggest mistakes you can possibly make. This is a mandatory court appearance. If you just don't show up, the judge will most certainly issue a warrant for your arrest. And that's going to make it harder to get bond and be released. What does that mean? It means the next time you have any interaction with a police officer, even for a simple traffic ticket, they're going to arrest you on the spot. They come to your house, come to your work. So that throws a huge wrench into the case. Not only does it get you arrested and put in jail, it also signals to the court that you might be a flight risk, which can increase your bail, right? It also makes it harder for an attorney to argue for a more favorable bail or release conditions that are beneficial to you, because they think you may not show up to court. So please avoid missing. Do not miss court. Do not miss court. Now, if you can't make it, contact the court, your attorney, whoever, to let them know, hey, you can't make it. This is the reason why, or you're running late or something like that. So they can let the court know, maybe get a new date, get a continuance or something like that so you don't get in trouble. Another question, do I have to speak at my arraignment? You actually say very little. Your main job is to be present, be respectful, and let your attorney do the talking. Or if you don't have an attorney, just answer the questions. They're going to ask you what your name is. They may ask you your birth date. Do you understand what the rights the judge is reading to you? Do you understand English? Something like that. When it comes to the end of the plea, in most places, they automatically enter a plea of not guilty on your behalf. So you don't even have to say not guilty. The court just needs to see that you're present and you're aware of what's happening. And are you going to hire an attorney? Yes. Or do you need a public defender? And they may end up asking you some questions involving your income about whether you can afford to hire an attorney. So that's basically the limit, the extent of what you have to say in court. Another question people ask is basically, like, how long does this initial hearing last? How long is it going to take out of the day? Like I said earlier, the hearing itself is surprisingly fast normally, but you may spend a couple hours at the courthouse just waiting for the case to be called up before you actually get in front of the judge, and then you're out of there in a couple of minutes. So it's usually longer to wait for your case to be called than it is for you to actually have the initial hearing itself. But if you got it in the morning, plan that whole morning. If you have it in the afternoon, plan that whole afternoon for your initial hearing. Those are some basic questions that people have in regards to the initial hearing, arraignment hearing in Indiana. That's your Nicholson Nugget of the day. Please be sure to like and subscribe.